Any mention for unlisted matter? Any mention for unlisted matter? From the main list, item number 1.
May I please, the Lordship? My Lord, in item number 1, my Lord, the first appeal which is filed by the state, my Lord, on the last occasion, Advocate General has made a submission that additional space is being provided to the, offered to the, my Lord, to the respondent. So, my Lord, in this regard, my senior is here, my Lord.
My Lord, there was an issue with regard to the size of plot and land. We have added the land and plot size also, my Lord, and we have invited them for signing the agreement, my Lord.
Yes, Mr. Khatri.
Lord, please, Lord, so kind, Lord. Lord, we have approached the central government also, and the request has been entertained. The request is being forwarded to the Joint Secretary. Lord, now the point is that this information which my learned friend is providing to us regarding the invitation with regard to the agreement, Lord, so far we have not received the formal letter or information, but if my learned friend is saying, we'll see that also.
No, we'll solve the problem. You pursue your back channel talks, you pursue your request through the central government, but let us take up the matter on merits and let's see what the merits are. Yes, so move your appeal and we'll do it on merits.
Yes, sir.
Yes, tell us what the
issue, the issue, my Lord, is that
first is, Lord, thing would be resolved, my Lord. This month the thing
we've waited for a long time, sir. Now the resolution has to be in accordance with law. Now let us see what the order impugned is and let us proceed on that basis.
In that case, Lord,
all 4 matters. There are 2 appeals, one appeal.
two appeals, my Lord. One by state and the other by the Hajjan Panchayat.
So in the 2 matters,
request, Lord, in that case, keep this matter for hearing. I'll come personally.
No. It's been kept for hearing today. Let's proceed.
No, Lord, I was not ready for the argument.
You should have been. You should have been, sir. Should have been. Let us hear them, and if necessary, we'll give you some time.
Yes. The issue is very short one, my Lord.
Yes.
We constituted a high-powered committee to look into the issues of unauthorized occupation by residents at the colony, my Lord. That committee.
Where is the colony?
This is next to, my Lord, near the Bala Bazaar. Near Bala Bazaar is there, just next. So this was there. The writ was filed challenging that decision to constitute the high power committee. Then the writ court, while deciding the matter, held that it involves disputed question of fact, and therefore the civil court will be having appropriate jurisdiction. And then direction was also passed, stating that before taking any action in accordance with law by the state should approach the civil court and get the order from the civil court. That was the order passed by the learned single judge, my Lord. The contention which we have, my Lord, that the writ court has held that it is a disputed question of fact, and
after that no order could have been passed.
That is my short submission.
And it's the same order which is been appealed against by them.
Yes, sir. Same order.
So it does not take 5 minutes for this appeal. Yes,
Lord, there are voluminous documents. There are 2 appeals, Lord. Other documents as well as applications are also there. My humble request.
Applications are irrelevant. We'll dispose of the appeal. What are the applications for? The writ says that there are disputed questions of fact. After that, the writ court could not have issued any further directions. What we will do is we'll dispose of the appeals. We'll give you liberty to approach the civil court within a period of 4 weeks from date. And for a period of 4 weeks, we will say that if you do it within 4 weeks, that they will take no action now. And after 4 weeks, they will be entitled to take action, which action will abide by the result of the proceedings.
Only one submission, my Lord. The land in question is covered by Meghalaya Public Premises Eviction Act, my lord.
Oh, so
At all.
So therefore, it's
so therefore you have to go before the estate
yes, sir,
manager.
estate officer.
Estate officer.
Yes, sir.
So you issue the notice under section 3.
Yes, sir.
And thereafter it will be done before the estate
Yes, in accordance with law.
71 Act.
Yes, sir. 1971 Act.
Very document.
The State Act, we have got Meghalaya
State Act.
Public Premises Eviction Act,
Which is which year?
it is also of same year only, my lord.
And we.
Yeah, I will just.
Meghalaya was not born in 71.
83, I'm sorry, my lord. It's mostly because 71 is the first one, and that is the act, my lord, which we have placed in our annexer also. This is the index. So it is, my lord, only under the Meghalaya Premises Eviction Act, that is the only ground which we have taken, nothing else.
Yes, but what is the name of the act?
Act is, my lord,
Eviction of Unauthorized Occupants Act.
yes, my lord. Meghalaya Public Premises Eviction of Unauthorized Occupant Act 1980.
1980.
Yes, lord.
That's it. There's nothing else.
Lord, I have many things to say, Lord. Kindly
You may
permit
have
me-
many things to say. You have many things to say. The many things may be about the weather. They may be about the upcoming Cricket World Cup. But we are not obliged to hear all that. The scope
Kindly,
of
my-
speech is
my
very
humble-
limited.
Your lordships have been so kind in this matter, Lord, earlier also, Lord. Only a respectful submission is, Lord, there are documents, Lord, when the state itself says
We
that
are
we
not
don't have
going
the
into
document.
it. We are not prejudicing you. We are not
Lord, my
prejudicing
humble
you.
request, this is not a disputed question of fact, Lord. When the document is there, document is already, Lord, admitted document, and that document is a government document. That the prayer of the writ may kindly be seen.
Take your whatever defense is available to you without complete prejudice. Your defense will be entirely before the estate officer.
Lord, allow me the
Estate
hearing.
officer, the entire proceedings are bad.
All right, my lord, allow me the hearing at least, my lord. My humble request.
Well,
Only
allow me
respectful
the
submission.
hearing. There's nothing else to it.
Lord, there are
If the
documents
case
that
which
show
is
from
being
the
dismissed without going into the merits, it's not even an appellable order. On your
From the
side, the
file-
appeal is not maintainable. On the state side, the appeal is maintainable to the extent that the writ court exceeded its authority. Your appeal is not even maintainable.
Lord, my appeal is with regard to that the writ is maintainable, my lord. That is what my humble submission is.
Writ
Lord,
may be
kindly permit-
maintainable, but the writ court has exercised the discretion that I don't want to go into these disputes, which is a discretion available with the writ court. And we find no reason to interfere with such discretion because that is the law of the land. That if there is an ethical alternative remedy, the writ court will not interfere.
So kind, my lord. But my lord, kindly see my grounds, my lord. If at least my grounds may be seen. If my grounds are there, my lord, may pass whatever judgment will be
There
passed.
may not,
will be
there is
found.
no ground at all. Let us finish it. You take it up with the central government. You also take it up before the Supreme Court.
That is a separate issue, my lord. That is a separate issue. When we are dealing with the appeal, my lord, kindly permit me to say my grounds. That's the only thing, my lord. I am requesting this. honorable court.
Tell us your grounds when you have finished. Tell us when you have finished. Yes.
Well, my lord, my humble request is, my lord, keep it, my lord, for after a week, my lord, keep it this matter. Nothing will happen, my lord, in this week, my lord. My humble request.
Third
Your
October.
lordship, so kind, my lord. Always
Despite
so kind
affording
to-
considerable time for a negotiated settlement, no settlement has been forthcoming. Paragraph. The state submits that following the requests by the relevant residents, the state has increased the extent of allocation and even the plot sizes. And even
Lord, this has been informed today.
And
Not been
even
served with any letter.
the
Lord. There is no
individual
affidavit, there is no
plot
letter.
full stop. The state says that there has been no response from the residents, full stop. However, the residents that the proposal upon increasing the extent of allocation or the plot sizes has not been forwarded. Full stop. Paragraph. It is the further submission on behalf of the residents that they have approached the central government and the central government is apparently looking into the request sympathetically. Paragraph. the legal issue is rather simple, full stop. The state purported to issue a notice to constitute a committee for the purpose of ascertaining whether the residents in this case duly occupied the properties that were in their, the land that was in their possession, full stop. It was such action of the state which was called into question by the residents by instituting proceedings under Article 226 of the Constitution, full stop. Ultimately, the relevant writ petition was disposed of upon the writ court perceiving that there were disputed questions of fact which could not be conveniently addressed in summary proceedings acted on affidavit evidence, full stop. The writ court left the parties free to pursue their remedies before any appropriate civil forum, full stop. However, there was a twist in the tail of the order, in the sense that the state was restrained from taking certain steps in the interregnum.
No, my lord, kindly see the order, my lord. The
Let us see
state
the
was
order.
not
Yes.
restrained.
Page 28, my lord.
My lord, my respectful submission is. Allow
Thank
me,
you, sir. Thank you. We've heard enough of you. Page 28.
I'll argue the
Paragraph
matter
7.
today. Lord, I'll argue the matter today itself. My lord, kindly permit me. My only respectful submission is permit me to say my stand, my lord. That's the only thing.
We've given you time. Say whatever you want to say. That's when you're finished.
Lord, both the parties were never sent, my lord. Only the state was asked to file a civil suit. Both the parties were never sent.
What did I say? Just give us a minute. However, there was a twist in the tail of the order impugned dated February 15, 2019. Paragraph 7 of the relevant order, which is the portion by which the state is aggrieved and an appeal, provides as follows, set out paragraph 7. Full stop. Yes. Now you make whatever submission you want to, Mr. Khatri. Yeah, we are hearing.
My humble request is, my lord. Lord, 1 week will be granted. Lord, we'll be submitting everything, Lord, before this.
3rd of October. 3rd of October. Please come on 3rd of October or appear virtually on 3rd of October. We will hear you. We'll dispose of the matter. We are just recording the facts over here. We are not disposing it off today.
All right, Lord.
Paragraph. The residents have preferred the appeal from the same orders. Full stop. It does not appear that the residents can be regarded as persons aggrieved for the appeal to be maintainable, since no prejudice has been occasioned to the residents by the order impugned, and the writ court merely exercised a discretion available to it to not enter into disputed questions of facts, since petitions under Article 226 of the Constitution are dealt with summarily and without recording evidence. Full stop. Paragraph. However, the residents maintain that it would be evident from government records that the primary assertion of the government, government records, that the primary assertion of the state that the residents appear to be encroachers is fallacious, and to such extent, they seek to suggest that the writ petition should have been entertained on merits and adjudicated. Full stop. Paragraph. since the matter has been lingering for a considerable period of time, comma, and a further adjournment is sought on behalf of the residents, comma, let the matter appear on October 3, 2023 for the appeals to be finally heard out. Yes. Option is yours, whether you do it virtually, because virtual over here, the virtual platform is equally efficacious as the real time is.
So kind, my lord.
Thank you.
The point is, my lord, your lordships were so kind when your lordships have permitted us to go for the mediation and the process started, my lord. The things were going very well. My lord, a month will take and the things will be solved, my lord. That
Yes,
is the
but
point,
then you must know how big to open your mouth. You know, if you open it so wide that you will swallow yourself inside.
We are not opening.
Yes.
We are not opening. Now the point is,
Very
the
well.
thing
Now
is
we'll
my
decide it
learned
on law.
friend
Now we'll not decide it on other points. We'll decide it on legal issues. Yes.
can be, my lord, kind appreciate, my lord. This can be possible, my lord. The letter is to be given by the state to us, my lord. The letter has not yet been given.
In
The
the
invitation
meantime-
which my learned friend
In the meantime, not in the meantime, in course of the day, the state's latest proposal should be communicated to advocate on record for the residents.
Yes.
kindly.
So I in fact spoken to him thrice.
He's
And-
saying
and
you don't have any formal proof. He's taking advantage of that. Yes.
Kindly, bro.